Ohio has a moderately regulated breaking lease framework with a statutory duty to mitigate and specific provisions that vary by local jurisdiction, particularly in Columbus, which has enacted additional tenant protections. The governing law is found in Ohio Revised Code Chapter 5321, the Ohio Landlord-Tenant Act, which addresses the landlord's obligations when a tenant vacates early. If you're a landlord or tenant in Ohio, the state provides a clear statutory foundation while local variations add complexity in certain cities. Let's start with the landlord's duty to mitigate damages. Under Ohio Revised Code Section 5321.16, when a tenant breaks a lease and vacates, the landlord has a statutory duty to make reasonable efforts to re-rent the unit. Ohio's mitigation requirement is codified and well-established. The landlord cannot leave the unit vacant and collect the full remaining rent from the departing tenant without making genuine re-rental efforts. The landlord must take reasonable steps, advertising the unit, showing it to prospective tenants, and accepting a qualified applicant. The landlord is not required to give the vacated unit priority over other available units or to accept an applicant who doesn't meet the landlord's legitimate screening criteria. But the landlord must treat the vacancy the same way they would treat any other vacancy. If the landlord re-rents, the departing tenant's liability is limited to rent for the vacancy period plus reasonable re-rental costs, advertising, cleaning, make-ready work, and leasing expenses. If the landlord fails to make reasonable efforts, the departing tenant's liability is reduced by the rent the landlord could have collected through reasonable mitigation. Ohio's statute also addresses the calculation of damages. The landlord can recover unpaid rent accruing after the tenant vacates, but only for the period before re-rental and subject to the mitigation duty. The landlord can also recover reasonable costs incurred in re-renting. If the replacement tenant pays less than the departing tenant may be liable for the difference through the end of the original lease term. Early termination clauses are generally enforceable in Ohio. The state does not have a specific statute capping early termination fees. Ohio courts enforce reasonable contractual provisions, and a clause requiring 30 to 60 days notice and a fee of 1 to 2 months' rent is typical and defensible. The fee must represent a reasonable estimate of anticipated damages. Ohio's general contract principles prohibit penalty clauses that are grossly disproportionate to actual losses. Ohio's Consumer Sales Practices Act may provide a basis for challenging early termination provisions that are unfair or deceptive, though the Act's application to residential leases varies by circumstance. Landlords should set fee amounts that reflect realistic re-rental costs and expected vacancy. Military members have the right to break a lease under the Federal Service Members Civil Relief Act. Active duty service members with qualifying orders can terminate by providing written notice and a copy of the orders. The lease terminates 30 days after the next rent due date. No early termination fee or penalty applies. Ohio's military population is significant. Wright-Patterson Air Force Base near Dayton is one of the largest Air Force installations in the country, home to the Air Force Research Laboratory, Air Force Materiel Command, and a massive civilian and military workforce. SCRA lease terminations in the Dayton-Fairborn area are common. Landlords near Wright-Patterson should have efficient SCRA processing as a core competency. The Ohio National Guard has facilities throughout the state, and various reserve units generate some rental demand. The former Defense Supply Center Columbus and other installations in the Columbus area generate modest military-adjacent demand. Ohio has enacted protections for victims of domestic violence that allow early lease termination. Under Ohio Revised Code Section 5321.17, a tenant who is a victim of domestic violence, dating violence, sexual assault, or stalking can terminate the lease by providing written notice and documentation to the landlord. The qualifying documentation must include a copy of a temporary or permanent protection order, a consent agreement issued by a court, or a police report documenting the domestic violence, sexual assault, or stalking. The tenant must provide at least 30 days written notice before the termination date. When a domestic violence victim terminates under this provision, the tenant is responsible for rent through the termination date, but is not liable for rent for the remainder of the lease term. The landlord cannot charge an early termination fee or penalty. The security deposit is handled according to standard rules, returned within 30 days of the tenant vacating. Ohio's provision also includes a specific protection for the victim's safety. The landlord must allow the victim to have the locks changed on the unit at the tenant's expense if the tenant remains in the unit and the perpetrator was a co-tenant or household member. If the victim terminates and vacates, the landlord must maintain the confidentiality of the tenant's documentation and cannot use the domestic violence termination as a basis for negative references. Ohio's provision also addresses situations involving co-tenants. If the victim and the perpetrator are both on the lease, the victim can terminate their individual obligation. The remaining tenant's lease obligations continue, and the landlord can pursue eviction of the remaining tenant, the perpetrator, if they violate the protection order or the lease terms. Tenants in Ohio may break a lease if the landlord fails to maintain habitable conditions. Under Ohio Revised Code Section 5321.04, the landlord has a duty to comply with applicable building, housing, health, and safety codes to make all repairs necessary to keep the premises in a fit and habitable condition, and to maintain all electrical, plumbing, heating, and ventilating systems in good working order. If the landlord fails to maintain the property and the failure materially affects health and safety, the tenant has remedies under Section 5321.07. The tenant must provide written notice to the landlord identifying the specific deficiency. The landlord then has a reasonable time to make the repair, typically 30 days for non-emergency conditions, though shorter timeframes may apply for more urgent issues. If the landlord fails to act within a reasonable time after receiving proper notice, the tenant may terminate the lease. The tenant must provide written notice of termination and must actually vacate. The tenant is not liable for rent beyond the termination date if the termination was based on the landlord's failure to maintain habitable conditions. Ohio's remedy structure for habitability issues also includes the option to deposit rent with the court, commonly known as rent escrow. Under Section 5321.07, the tenant can deposit rent with the clerk of courts rather than paying the landlord, and the court can order repairs or reduce the rent based on the diminished value of the property. While rent escrow is not the same as lease termination, it's an intermediate remedy that can lead to termination if the landlord refuses to comply with a court order. Ohio also recognizes constructive eviction as grounds for termination. If the landlord's failure to maintain the property or affirmative actions, shutting off utilities, removing doors or windows, failing to address dangerous conditions, render the unit uninhabitable, the tenant can treat the lease as terminated. The tenant must vacate within a reasonable time. Columbus has enacted additional tenant protections that may affect breaking lease situations within the city. Columbus Fair Chance Housing Ordinance and other local provisions create a more regulated environment than the rest of the state. Landlords in Columbus should verify current local requirements that may affect how broken leases are processed, including any additional notice or procedural requirements. Cleveland and Cincinnati have also been active in tenant protection discussions, and additional local provisions may apply. Landlords in Ohio's major cities should monitor local developments. Ohio has specific provisions regarding abandonment. Under Section 5321.15, if a tenant abandons the property, the landlord can retake possession. The statute provides that the landlord may consider the property abandoned if the tenant is absent for a period and rent is unpaid. The landlord should document evidence of abandonment, unpaid rent, absence from the property, removal of belongings, disconnected utilities, before entering and re-renting. The departing tenant remains liable for damages subject to the landlord's mitigation duty. Ohio's notice requirements for lease termination also affect the breaking lease context. For month-to-month tenancies, either party must provide 30 days' notice before termination. For fixed-term leases, the lease governs. But even when a tenant breaks a fixed-term lease, the amount of advance notice the tenant provides affects the landlord's ability to mitigate. More notice gives the landlord more time to begin marketing the unit before it becomes vacant. From a practical standpoint, Ohio has a large and diverse rental market with several major metros that each have distinct dynamics. Columbus is Ohio's largest city and one of the fastest growing in the Midwest. The economy is driven by state government, Ohio State University, healthcare, including Ohio State Wexner Medical Center and Ohio Health, financial services, technology, and insurance. When a tenant breaks a lease in Columbus, re-rental times vary by area. The Short North, German Village, Grandview Heights, and University District have strong demand and can be re-rented quickly, often within 2 to 4 weeks. More outlying areas take longer. Ohio State's massive enrollment creates enormous student rental demand. Student lease breaks timed to the academic calendar fill quickly. Mid-year breaks in the University District take longer, but the overall depth of Columbus market means vacancies don't persist long in most areas. Cleveland has a diverse market driven by healthcare. The Cleveland Clinic and University Hospitals are the region's largest employers, manufacturing, financial services, and higher education. Revitalized neighborhoods like Ohio City, Tremont, and University Circle have strong demand with quick re-rental. Other parts of the metro have more moderate demand and longer re-rental times. Cincinnati has a growing market driven by healthcare, including Cincinnati Children's Hospital, consumer products, Procter & Gamble, Kroger, financial services, and higher education. The Over-the-Rhine neighborhood has experienced dramatic revitalization. Re-rental in Cincinnati's desirable areas is typically quick. Dayton has a moderate market heavily influenced by Wright-Patterson AFP. Military and civilian defense employees represent a major portion of the rental market. SCRA lease terminations are common, and the regular rotation of personnel creates predictable vacancy patterns. Re-rental near Wright-Patterson is generally moderate. The steady stream of incoming military and civilian personnel helps absorb vacancies. Toledo, Akron, Youngstown, and Canton have more affordable markets with varying demand. These cities have experienced population decline and economic challenges. Re-rental in some areas can take longer. Landlords in these markets should set realistic expectations and calibrate their lease terms accordingly. Athens, home to Ohio University. Bowling Green, home to Bowling Green State University. Kent, home to Kent State. And Oxford, home to Miami University, have student-driven markets with strong seasonal patterns. Lease breaks timed to the academic calendar are absorbed quickly. Mid-year breaks take longer. One best practice for Ohio landlords include a clear early termination clause in your lease that works alongside Ohio's statutory mitigation duty. Structure the clause so the tenant has a defined path-specific notice period and fee, while preserving your right to recover actual damages if the tenant abandons without using the formal process. A typical clause might offer 60 days notice and a fee of 1.5 to 2 months rent, or actual damages including vacancy rent and re-rental costs, whichever is less. Another best practice, begin re-rental efforts immediately when a tenant provides notice or when you discover abandonment. Ohio's statutory mitigation duty under Section 5321.16 is enforceable, and your documentation proves compliance. Keep records of listing dates, advertising platforms, inquiry counts, showing dates, and when you accepted a replacement tenant. In Ohio's major metros where the market is competitive, demonstrating prompt action establishes your credibility and limits disputes. A third best practice, understand Ohio's rent escrow process under Section 5321.07. If you receive notice that a tenant has deposited rent with the court because of habitability complaints, respond immediately. A tenant who uses rent escrow is signaling that they may terminate if repairs aren't made, and a court order to repair that goes unfulfilled can lead to lease termination with the landlord bearing the cost. Addressing habitability complaints promptly prevents the escalation to rent escrow and reduces the risk of lease breaks based on habitability. Ohio limits the security deposit to 1 month's rent plus any pet deposit. The deposit must be returned within 30 days of the tenant vacating, along with an itemized statement of any deductions. For deposits exceeding $50 and tenancies longer than 6 months, the landlord must pay 5% annual interest on the deposit. If the landlord fails to return the deposit within 30 days, the landlord may be liable for the full deposit amount plus damages and attorney's fees. These rules apply whether the departure is a normal move-out or a broken lease. For the complete guide to Ohio breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.